Thank you, Madam Secretary, for your remarks. And now please help me welcome Federal Student Aides Jeff Appel and the Office of Post-Secondary Education's Lynn Mahaffey for the federal update.
Good morning. I hope everybody had a great Thanksgiving and that you had a chance to rest and be with friends and family. I heard yesterday was a very tough travel day for some of you, so we really appreciate you coming right back after the holiday and joining us. We're thrilled to have so many people here, and Jeff and I are glad to be here. So Jeff and I are going to go over some of the highlights of what the department is working on, and I will focus on the regulatory work we're doing, and then I'll turn it over to Jeff, who will talk about some statutory changes and FSA processing and next gen and a few other cats and dogs kinds of issues. So with respect to regulations, I'm going to talk about two major topics. One is regulatory reform, which is sort of the umbrella for all of our regulatory work. And then I'm going to talk about three packages that we're actively working on. One is a new package on accreditation and innovation. The other two you have probably heard us talking about before, borrower defense to repayment and gainful employment. At the very beginning of this administration, the President signed an executive order that asked all agencies to look at how we can reduce burden on the American people. That has really become the foundation for the regulatory work that we have done in this administration. In response to that executive order, the department created a regulatory reform task force. The task force consists of career employees from every office working side by side with our political leadership. And our task is to identify regs that eliminate jobs or inhibit job creation, are outdated, unnecessary, or ineffective, impose costs that exceed burdens, or otherwise impede our efforts to do regulatory reform. Last fall, we held public hearings in Salt Lake City and Washington, D.C., and we accepted written comments asking you what were the burdens you faced, how could we improve our processes and regulations to make it easier for you to administer the Title IV programs. We received hundreds of ideas from you and your colleagues across the country on a very broad array of topics, and it was exceedingly helpful to us to be able to hear about your challenges and how we can help address them. And that helped us set priorities for moving forward. So one of the first things that the Regulatory Reform Task Force did, and we started this before we had even done the public hearings, was we have started looking through guidance to see what is outdated and pull that down. As part of that effort, we looked through Dear Colleague letters on IFAP, and we identified hundreds that were outdated. And we have maintained them on IFAP for historical purposes, but we clearly marked them so that all of you know that you no longer have to comply with those letters. We are continuing that work, and I anticipate that we will identify future letters that are outdated that can come down. As the Secretary just indicated, innovation is a huge component of her agenda for higher education. And to help allow for more innovation, we are about to start a negotiated rulemaking on accreditation and innovation. We will begin that work in January. The committee will address a number of issues, starting with the Secretary's recognition of accrediting agencies, including accrediting agency oversight of institutions, as well as the criteria that the Secretary uses to determine which accrediting agencies she will recognize. Our goal is really to simplify the accreditation process and to clarify the role of the triad. And when I say the triad, I mean accrediting agencies, states, and the Department of Education, all of which play a role in the oversight of institutions. And we are working to make sure that we minimize any overlap between the oversight of those three entities. We are also going to address other issues such as the arrangements between institutions and other entities to provide portions of educational programs. We will also be looking at the roles and responsibilities relating to teach out. Because we are taking on a lot of big issues and we need expertise on all of them, we have decided to create 3 subcommittees that will provide recommendations to the full committee on a number of specific issues. The first is distance learning and innovation. The second is eligibility of faith-based entities. And the third is teach grants. So the first subcommittee on distance learning and innovation is going to take on a number of really meaty issues, focusing on barriers to innovation and barriers to student achievement. Many of these issues are tough issues that all of us have been grappling with for many years, including state authorization of distance education, regular and substantive interaction, the definition of credit hour and program length. And of course, we'll also be looking at direct assessment and competency-based education. For the Teach Grant Subcommittee, we have heard a great deal from all of you that there is a lot of room for improvement in the Teach Grant program to minimize the number of grants that get converted to loans. We have created a separate subcommittee to address those issues, to look at the recommendations that we've received from the field, as well as thoughts we have within the department for maximizing the potential of the Teach Grant program. In addition to the regulatory work that we're about to take on the Teach Grant program, we are also looking at whether there's administrative things we can do to improve the Teach Grant program. And we anticipate that we will be able to make improvements before we are able to do regulatory changes, which will take longer. The final subcommittee will look at issues regarding eligibility of faith-based entities to participate in Title IV programs. And by Title IV programs, I mean both the federal student aid programs as well as discretionary grant programs such as the Gear Up program. We are also looking at the requirement of accrediting agencies to honor the mission of individual institutions, both in the context of missions that are faith-based, as well as the whole variety of missions of your various institutions. Before beginning the work of this negotiated rulemaking committee, we held 3 public hearings, the first in Wisconsin, one in New Orleans, and one in Washington, D.C., to gather feedback from the community. We had a lot of participation, and we received many written comments, and that was very helpful as we frame the issues going forward. We recently submitted requests for nominations for committee members as well as subcommittee members to represent various affected groups. The nominations were due right before the holiday on November 15th, and we are currently reviewing them, and we will announce membership of both the committee and the 3 subcommittees next month in December. The dates for the 3 rounds of negotiations are up on the screen, January 14th through 16th, February 19th through 22nd, and March 25th through 28th. All of these negotiations are open to the public. If you are in Washington, D.C. or want to come specifically for it, we welcome you. They will all take place in Department of Education buildings in Washington, D.C. We will have the specific locations published in a Federal Register notice, and we will also post them to our website. So feel free to join us. This year, we're going to do the negotiations a little bit differently than we've done in the past. For those of you who have followed negotiated rulemaking, you probably know that the first round of negotiation has typically been very general on the issues, and given the number of issues we're working on, we really wanted the committee to be able to dig in right away. So we are going to the first round of negotiations with specific proposals to be discussed at the first round of negotiations. The subcommittee dates, the subcommittees will also meet in January, February, and March, January 17th and 18th, February 12th and 13th, and March 11th and 12th. Those subcommittee meetings are going to be live streamed, so if any of you want to follow from home, if you're inclined to do that, you are welcome to. Many of you may recall that in 2016, the department published final regulations regarding borrower defense to repayment. Those regulations did a number of things, but the key things is they created a federal standard for borrower defense. They prohibited mandatory arbitration clauses and provided for automatic closed school discharges. This year, the Department of Education formed a negotiated rulemaking committee to rethink those regulations. And part of that committee looked at the issues that were discussed in the 2016 regulations. And we also added some additional items, such as we looked at some limited aspects of financial responsibility regs. We also looked at guarantee agency collection fees and subsidized usage periods. The borrower defense to repayment negotiated rulemaking included a subcommittee specifically to look at financial responsibility. As all of you know, financial responsibility is a huge topic. We did not take it all on. We limited it, focusing on recent FASB changes that needed to be addressed quickly. The committee reported to the full committee on their recommendations, and the committee discussed those. We published a notice of proposed rulemaking on borrower defense to repayment, and in response, we received about 32,000 comments, so it was a huge response. We thank you all for your interest and for taking time to share your views with us. The department is currently reviewing the comments that we received, and we are working to publish final regulations. Over a year ago, the department published notices to delay implementation of the 2016 borrower defense to repayment regulations. In October, the U.S. District Court for the District of Columbia invalidated the delay, and the 2016 regs became effective. So those regs became effective, and we are now working on final regs that we hope to publish soon. Also, beginning last December and in early this year, we held a second negotiated rulemaking committee on gainful employment. That committee met in December, February, and March to consider issues about gainful employment. The committee did not reach consensus. We published a notice of proposed rulemaking in August, and in response, we received about 14,000 comments. Again, we appreciate the interest that all of you have taken and sharing your views. The comment period ended on September 13th, and we are now working on final regulations. And with that, I will turn it over to Jeff.
Thank you, Lynn. Pending implementation of a new final regulation for gainful employment, I wanted to briefly highlight some of the requirements that are still in effect and some provisions that have been delayed. Under current regulations, institutions must disclose information about their GE programs to enrolled and prospective students using a template provided by the department. The information conveyed includes the percent of students completing a program timely, program cost, debt levels of typical borrowers, placements rates, and licensure requirements. Institutions are still expected to disclose this information on their web pages, and the deadline for 2018 was this past April. However, as previously announced, the deadline for including the template or a link to the template in any promotional material, as well as for directly distributing the template to students, has been delayed until July of next year. We have developed resources for institutions to use with respect to the 2018 GE disclosure template, including a quick start guide that takes users through the basic steps required to configure and host a web page containing the required disclosures on a program-by-program basis. We will be developing new resources for the required 2019 GE disclosures, so keep your eyes open for these. GE reporting requirements for institutions also remain in effect. Data to be reported includes information about your GE programs and the students enrolled, and the private loans received and institutional debt owed by students as a result of program enrollment. GE reporting for the 2017-2018 award year was due October 1, 2018, and GE reporting for the 2018-19 award year will be due October 1st, 2019. We have 3 sessions this week devoted to gainful employment. It's session number 20 in your programs, and they'll be offered tomorrow and on Thursday. I'll now cover a few important items that were included in recent legislation. At the end of September, the President signed legislation that provides the Department of Education and the programs it administers with funding for fiscal year 2019. This was a bit unusual in comparison to recent years in that Congress actually passed an appropriations bill for education in advance of the start of the year. In addition to funding the student aid programs, Congress included a new benefit for some borrowers, continued a provision concerning the sharing of FAFSA data, and similar to last year, provided additional funding that temporarily expands eligibility for public service loan forgiveness. With respect to the Pell Grant program, Congress has provided for a $100 increase in the maximum Pell Grant award for the 2018-19 award year, so the new maximum grant will be $6,195. This is the second consecutive year that Congress has specifically provided for an increase in the maximum Pell Grant. Prior to the last 2 years, there was a provision in law that provided for an automatic increase in the maximum grant based on inflation. However, that provision sunset with the 2016-17 award year, so any increase in the maximum grant now requires specific action by Congress. You may recall last year we issued Pell Grant payment and disbursement schedules at the end of January, even though Congress had not yet passed a final funding bill. By law, the department is to publish the schedule by February 1st. We subsequently had to issue a revised schedule in April after Congress finished its appropriations work. Fortunately, we'll be able to avoid a repeat of that this year. We are currently working on developing the Pell Grant payment and disbursement schedule and expect to have that out in the coming weeks. As a reminder, beginning with the 2017-2018 award year, a student may be eligible to receive Pell Grant funds for up to 150% of the student's Pell Grant scheduled award for an award year, what is often referred to as year-round Pell Grants. For additional information, you can see our Dear Colleague letter, Gen 1706. For the work study and SEOG programs, Congress level funded the programs this year, so they'll receive the same amount as last, about $1.1 billion for work study and $840 million for FSEOG. This year, Congress also established a new deferment for some, but not all, federal student loans. For those loans covered, borrowers who are receiving treatment for cancer and for the 6-month period following the end of such treatment need not make payments on their loans. Borrowers will also not incur any interest charges on their qualifying loans during the time of this deferment. This interest benefit applies to both subsidized and unsubsidized student loans. However, this deferment is only available for loans that are disbursed on or after September 28, 2018, the date of enactment of the provision, or loans that were in repayment on that date. It excludes loans that were dispersed prior to September 28th and that have not yet entered repayment. Even when these loans go into repayment, they will not qualify for the deferment. So in the future, it may be that a borrower has a mix of loans, some of which qualify for the deferment and some of which do not. We are working on creating a new form for borrowers and servicers to use for this new deferment. In the meantime, servicers are able to offer temporary forbearance for borrowers who may be eligible for this benefit at the borrower's request. We expect to have the new form available soon. Another provision included in the appropriations bill this year was a modified version of a provision included in last year's appropriation bill concerning the use of FAFSA data. As you will recall, a provision in the Higher Education Act restricts the use of FAFSA data to the administration and award of federal, state, and institutional aid. That created difficulties in cases where third-party scholarship organizations had relied on access to FAFSA data in making scholarships available to students. The provision included in law last year permitted institutions to share FAFSA data with these scholarship organizations, provided that students gave their consent in writing to the institution to share these data with scholarship providers. Congress modified this provision in the most recent appropriations bill to expand the organizations with which FAFSA data can be shared. Now institutions may also share FAFSA data with organizations that assist applicants in applying for or receiving federal, state, local, or tribal assistance. Again, the applicant must provide explicit written consent for the data to be shared. And the provision does not require institutions to share data, but permits it. We hope institutions will continue to exercise diligence in ensuring that data are only shared with organizations they trust are legitimately working in the best interest of students. In Session 21, presented tomorrow, Thursday, and Friday, you can learn more about the use of FAFSA data and student privacy. This year's appropriations bill directed that some of the administrative funding provided to FSA be used to perform outreach to all direct loan borrowers concerning the Public Service Loan Forgiveness benefit. We'll be engaging in outreach to borrowers about the benefit as well as using funding to enhance our operations of the program. Earlier this year, we made information publicly available at the FSA Data Center website concerning the Public Service Loan Forgiveness applications and discharges made to date. As a reminder, the benefit was first established in law in 2007 and is restricted to direct loan borrowers. It requires borrowers to make 120 payments while working full-time in public service jobs. It also restricts the benefits to borrowers in certain repayment plans, principally the 10-year standard repayment plan or any of the income-driven repayment plans. The 10-year standard repayment plan would mean, of course, that a borrower would typically pay off their loan in 120 payments. So borrowers would typically need to be repaying their loans under an income-driven repayment plan to see any benefit after making 120 payments. Also, while the initial income-based repayment plan was established in the 2007 law as well, the law did not make it available to borrowers until 2 years later in 2009. The first time any borrower could have possibly qualified for forgiveness was at the end of 2017. The data we released earlier this year reflects that a few borrowers did qualify for forgiveness. As of June 2018, around 28,000 borrowers had applied for forgiveness. Of these, about 100 were approved, and these borrowers received forgiveness of over $5.5 million. Many of the applications we received were not approved, the very large majority due to borrowers not having direct loans, or not having made 120 payments, or not being in the repayment plans required by law. Like last year, the appropriations bill this year also provided a sum of $350 million to temporarily expand the Public Service Loan Forgiveness Program to include borrowers who have made 120 payments under repayment plans that were not included in the law that first established the benefit. The benefit is still restricted to direct loan borrowers. The special funding is available to provide forgiveness to those borrowers who may qualify under the new provisions, on a first-come, first-served basis. While the law expanded the types of repayment plans that can qualify borrowers for the benefit, it included other restrictions. For example, while non-income-driven repayment plans can qualify, a borrower must demonstrate that the payment they made 12 months prior to applying for the benefit and their most recent monthly payment prior to applying are at least as much as they would have paid under an income-driven repayment plan. The law does permit exceptions to this requirement for borrowers who experience unusual fluctuations in income over the most recent 5 years. When Congress first established the new temporary expanded public service loan forgiveness provision, they directed the Department to implement it within 60 days. We did that and began accepting requests for the benefit earlier this year. As of the middle of last month, we have received well over 30,000 requests for consideration for forgiveness under the new temporary provisions. A couple of dozen borrowers have been approved for forgiveness of about $1.5 million. Many of the requests we have received have been from borrowers who have not yet applied for public service loan forgiveness, a necessary step before seeking forgiveness under the temporary program, which is limited to borrowers who do not otherwise qualify for public service loan forgiveness. Of those borrowers submitting requests who had taken this step, many have not met or yet met the statutory requirements for forgiveness. About 20% of those requesting for forgiveness did not have direct loans, and only these loans are eligible. And over 60% of those requesting forgiveness have not been in repayment for 10 years, another statutory requirement for loan forgiveness. We're offering a session on public service loan forgiveness and the recent expansion of it, where you can learn more about it. It's session number 22 and is offered today, tomorrow, and on Thursday. As you may have seen, we recently issued an announcement concerning a new financial aid benefit Congress established in the 2018 appropriations bill passed earlier this year, called the Children of Fallen Heroes Scholarship. Congress amended the needs analysis section of the Higher Education Act to provide the scholarship, which is available beginning with the 2018-19 award year. To qualify, a student must be Pell eligible and had a parent or guardian who died in the line of duty while performing as a public safety officer when the student was under 24 years of age, or any age if the student was enrolled in an institution at the time of the parent's death. For such a Pell eligible student, the new statutory provision provides that the student be awarded Pell and other Title IV aid based on an EFC of 0, regardless of the student's calculated EFC. As you'll find in the announcement, the new law establishes definitions for public safety officers, which includes law enforcement officers, firefighters, ambulance crews, and fire police officers. The new benefit is somewhat akin to the Iraq and Afghanistan service grant in that a Pell-eligible student becomes eligible for a maximum Pell Grant award regardless of their EFC. However, it is unlike the Iraq and Afghanistan service grant in that if a student is not Pell eligible, they do not qualify for the Pell Grant. Also, unlike the Iraq and Afghanistan service grant, there's no national database of individuals who died in the line of duty while serving as a public safety officer. So we will be unable to flag FAFSA applicants who may be eligible for the new scholarship. This means financial aid administrators will need to determine and document, in collaboration with the student, that the student qualifies for the Children of Fallen Heroes Scholarship. Our recent electronic announcement provides a few examples of how you might document eligibility. We also recently have made changes to the COD system that will allow institutions to certify eligibility for students who qualify for the scholarship and allow for increased Pell Grant disbursements. I wanted to touch briefly on Perkins loans. As you know, the program has come to an end. No new loans nor any disbursements should be made. Dear colleague letter Gen 1605 discussed the last time frames during which loans could be made and disbursed. Their colleague letter, Gen 1710, discusses the wind down of the program, including the assignment of loans to the department for institutions that wish to do so. DCL 1710 also discusses the distribution of assets from institutions' federal Perkins loan revolving funds. By law, institutions must return to the department the federal share of the revolving loan funds. Institutions may not reimburse themselves for prior loan cancellations. In the past, the Congress has appropriated funds specifically for a reimbursement of Perkins loan cancellations, but it has not done so for several years. In the DCL, we noted that the department would begin collecting the federal share of institutions' loan funds following the submission of the 2019-2020 FSA, and that we would not take into consideration unreimbursed cancellation amounts in light of the fact that Section 465B of the Higher Education Act prohibits the use of funds appropriated for federal capital contributions from being used for cancellation reimbursements. We know, however, that unreimbursed loan cancellations are a significant issue for many institutions. While we had originally planned on notifying institutions next month of the amount of federal capital contributions that need to be returned, we are holding off from doing that for the time being while we continue to assess whether there are any avenues that can be pursued to address this issue. We hope to update the community on this issue in the near future. We have a session devoted to Perkins loans and how the wind-down process will generally work. It's session number 16 and will be offered today, Thursday, and Friday. Now on to verification. Jim Manning, as you heard, our Chief Operating Officer at FSA, discussed some of the changes we'll be announcing in the coming weeks concerning verification, and I'll mention these again in a few minutes. But first I wanted to review some of the changes that I know many of you have already seen as you and students complete the verification process. Preventing fraud and protecting personal identifying information will continue to be a major focus for all federal agencies, including education and IRS. To better protect and secure PII, personal identifying information, IRS has and will continue to introduce changes to tax transcripts and third-party services. At the end of September, IRS introduced a new version of tax transcripts that redacts sensitive PII of tax filers. The redactions apply to transcripts requested via 4506T and electronic service systems. As shown here, the transcripts only display a selected number of characters of the tax filer's name, SSN, and contact information, but all financial data, including balances due, interest, and penalties, continue to be displayed without redaction. Despite the redactions, institutions should still be able to identify and match the tax data and the FAFSA data provided by the applicants. For this reason, the IRS tax transcripts are still acceptable documentation for verification purposes. Other changes instituted by the IRS include those made to Forms 4506T and 4506T-EZ. In particular, IRS has added an optional customer file number that taxpayers can assign to their tax return transcripts. This might help in terms of matching the transcript to the individual students. As long as it's not an SSN number, this number could be, for example, a student ID number. Now, to step back a little on the verification issue, as Jim Manning mentioned earlier, we've made improvements to the verification selection process this year, and the rates at which applicants are selected are lower than the year before. We're using a new model to better target applications that are more likely to be prone to errors and consequently improper payments. Improper payments occur when federal funds go to recipients in the incorrect amounts, either overpayments or underpayments, or documentation is not available during review to discern that a payment is proper. Both the Pell Grant and direct loan programs have been deemed high priority or high-risk programs with respect to improper payments. And by law, that means the programs are subject to more scrutiny. Congress, too, has been scrutinizing agencies' efforts, including the Department of Education, at reducing improper payments. And regardless, the department wants to ensure that we are effective stewards of taxpayer funds. Improper payments are harmful to the integrity and reputation of the federal government and degrade the public's trust in federal payment systems. We do, of course, recognize and aim to balance this responsibility with the goal of promoting efficient and accurate payments to students. We are currently conducting analyses looking at the efficacy of verification and the efficiency of the selection and correction processes, and we aim to share information publicly about this in the future in a way that doesn't compromise the process. Among the things that we are looking at is the extent to which FAFSA applicants indicate that they have not and will not file taxes. I know that some had raised questions about whether the incidents to which we saw this issue surface in the past might have been related to the use of prior year tax information, and that perhaps the introduction of prior year may reduce it. Based on looking at more recent information, however, it still appears that a not insignificant number of applicants who report they have not filed taxes, in fact, did. We're still reviewing these data and issues. We're also looking at and interested in what some are calling or referring to as verification melt. In particular, we're comparing groups of students who are similar in terms of being selected for verification and comparing those who were versus those who were not. The difference in terms of whether these students eventually receive aid are far smaller, but not insignificant, than the differences found by others researching the same issue. Our differences in methodology may account for this. We're looking at more recent data and experience and looking at different comparison groups. We're still working on our analysis, but hope to have something to share publicly in the near future. And again, to repeat what Jim mentioned earlier, we'll be issuing forthcoming guidance on alternative documentation to help address some of the difficulties students are having with the verification process currently. Obviously, what all these issues highlight, as we all know, is how key the use of the IRS DRT is for those folks who are eligible to use it. It is a win for applicants in terms of simplifying the application and obviating verification issues, a win for institutions in terms of reduced verification burden, and a win for the department and taxpayers in terms of meeting its obligations to reduce improper payments. And as Jim mentioned, there's an exciting piece of legislation that has been introduced in Congress that could even take us a leap forward by providing the department easier access to applicants' tax data. It's the Bipartisan FAFSA Act of 2018, S 3611. Returning to recently passed tax legislation, I just wanted to mention that the IRS is currently working on revamping the tax return forms we all know and have come familiar with in recent years. IRS released draft new forms late this summer. Among the proposed changes are the elimination of tax forms 1040A and 1040EZ and the creation of 6 new schedules. We're currently reviewing these changes to see how they may affect our own forms and processes. Our session on verification follows our general update here after a short break. We wanted to highlight that we have 3 sessions offered Wednesday through Friday that will discuss the new electronic process the Department of Homeland Security has to assist institutions verify the eligibility of non-citizens. This new process replaces what used to be a paper-based process. And as you heard Jim mention, we've been very busy at work at FSA establishing a modern, world-class student aid delivery system. And you'll hear all about it at about our action and plans tomorrow from Dr. Wayne Johnson. You won't want to miss it. You'll also hear tomorrow about the tremendous progress we've made over the past year with respect to improvements that make it easier than ever to apply for federal student aid, in particular our new mobile FAFSA app and process. So please make sure you make note of the times for our updates on the next-gen FSA and FAFSA updates tomorrow morning. Finally, we have a few updates and reminders. This year, we saw a noteworthy decline in the cohort default rates. The rates released earlier this year reflect borrowers who entered repayment in fiscal year 2015 and whose loans were tracked through September 2017. As shown here, the national rate declined to 10.8%. You can learn more about cohort default rates today and tomorrow by attending session 32. Given the horrible natural disasters we've been witnessing recently, we wanted to remind you about our existing guidance and information available. Our Dear Colleague letter, Gen 1708 in particular, applies to students and institutions affected by any federally declared major disaster and discusses various regulatory relief available. You might want to review this. And in general, if you find yourselves affected by a disaster, please contact us to discuss how we might be able to help. To provide a bit of an update with respect to students and institutions affected by hurricanes in Puerto Rico and the Virgin Islands last year, we'll be providing some assistance to students as a result of some flexibility provided the department under specific legislative authority passed in February. In particular, we'll be announcing that we're waiving some requirements for teach grants, canceling some loans, and providing relief concerning SULA and Pell LEU requirements. We continue to be concerned about so-called debt relief companies that purport to help borrowers, but in reality do not. These companies can use sophisticated strategies to target unsuspecting borrowers and dupe them into paying services or benefits that they can get for free. We encourage everyone to let us know of any suspicious activity via FSA's feedback system, where we can help track and resolve issues. There are also things institutions can do to help borrowers avoid being scammed. Warning them about such scams, informing students that they do not need to pay for loan benefits, and ensuring your own information is up to date concerning loan terms, conditions, and servicing. We have a couple of electronic announcements you might want to take a look at, illustrating some of the actions the department has taken. In particular, the December 2016 electronic announcement discusses that an obsolete phone number from a former direct loan contractor was purchased by one of these so-called debt relief companies. So we encourage institutions to make sure that this number no longer appears on any of your institution's web pages or contact lists. Continuing on to other cybersecurity issues, we issued an announcement this past summer to warn institutions about a malicious phishing campaign that attempts to intercept and redirect students' credit balance disbursements. The announcement includes suggested remediation steps if institutions are a victim of such an incident. We're continuing to monitor the situation. Please keep this contact information handy and let us know if you suspect you've fallen victim to such an attack. Just a few more reminders before we finish. Please bear in mind your institution's responsibility for ensuring any third-party servicer you have uses NSLDS data only for the purposes for which your institution has contracted with them to perform. And please make sure you take care to ensure the data you report to the department is accurate. It has significant consequences for your students and for your institution and the public, because some of these data are used for key transparency initiatives and purposes, including the College Scorecard, the College Navigator, and more. And finally, I just wanted to point out a reminder that as of August 31st, FSA no longer prints or delivers FSA publications. We will make available paper FAFSAs to applicants upon request, but it will be a paper printout of an electronic version available on our website. Thank you all for attending this morning's initial meetings, and we look forward to seeing you, if not in the next few minutes, then later throughout the week.